In this video, you'll learn about the different types of Florida workers' compensation cases, including information, examples, and tips that I think you should know. If this is your first time to my channel, my name is Domenic Celeste, the virtual accident attorney. I'm based in Palm Beach County, Florida, and I represent those injured on the job in workers' compensation and due to the fault of another in personal injury. This channel is all about answering your questions and giving you tips relating to Florida workers' compensation and personal injury law. Now before we get into the video, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. Firstly, to even qualify for workers' comp, your injury or condition must have occurred by accident and arose out of the course and scope of your employment. So what does that mean? Basically, you had to have gotten injured while doing what you would normally do at work. One thing that you should know relating to all accidents is that you have to report your injury within 30 days of when you knew or should have known that it was related to your employment. And remember, you have to report it to your supervisor and it needs to be in writing. If you want to learn more about this, check out the video that I made linked in the card above. Alright, so now let's get into the different types of accident cases that exist under Florida workers' compensation law. The first and most common is an acute accident. This is an accident that happens one time and causes injury. Some examples include falling off a roof or a ladder, motor vehicle accidents, or even lifting something too heavy. The next type of case is called a repetitive trauma accident. A repetitive trauma accident isn't just one event that causes an injury. Rather, it's a sequence of smaller events that then culminate into an injury. Some common examples of this are carpal tunnel from repetitive typing, low back injuries from repetitive bending, shoulder injuries from repetitive lifting, or knee injuries from repetitive kneeling. Now, a big problem with repetitive trauma accidents is you don't know the exact date of accident because there wasn't one event. For repetitive trauma cases, the date of accident that's typically used is the date that your doctor relates your pain to your employment. But a little tip here is if you're experiencing pain while at work, just report it to your employer whether you know that it's related to your employment or not. And the next type of accident case are exposure cases. And this type of case exists whenever you're exposed to some sort of chemical or substance that then results in a medical condition. Some common examples of this are exposure to a substance like mold or chemicals like fertilizer or chlorine. Exposure cases are almost impossible to win because not only do you have to measure the exact amount of your exposure, but then you have to get medical evidence to correlate it to your condition. And the big problem here is if whatever you were exposed to has been removed or destroyed, how can you measure it? Another type of accident case is when you aggravate, exacerbate, or accelerate a prior injury or condition. And this usually happens after an acute accident, but you've already had this injury or condition in the past. Workers' comp will usually deny these cases and just point the finger at your prior injury or condition. In order to be covered though, the current state of your injury must be reasonably attributable to your accident. And the way you do this is through medical evidence and your history. So basically what you need is your doctor to relate the current state of your injury to your accident and your history to show no recent complaints or treatment. It's also strong evidence if you're able to perform your job without any issues until your work accident. An example of this is say you injured your knee 10 years ago, but you've been able to perform your job as a roofer without any issue until you had your work accident. Another common example is that you have arthritis, but you've never had any pain or treatment until after your work accident. A tip here is that you need to keep record of your medical history, and that includes your own notes and reports from your doctors. Another type of accident case that a lot of people don't even know could be covered under workers' comp is due to overuse or overcompensation. And this happens when you injure another body part due to overuse or overcompensation for the original work-related injury. You see this a lot with upper extremity injuries. For example, say you injure your right dominant arm at work, but now you're feeling pain in your left arm. Can it be argued that but for your right arm injury at work, you would not have had to use your left arm as often? And therefore, any injury to your left arm is due to not being able to use your right arm. Now, just to be clear, the overuse or overcompensation injury wouldn't be its own separate case. Rather, it would fall under the original injuries case. And along those same lines is something called the hindrance to recovery theory. So this theory isn't a separate accident. Rather, like the overuse or overcompensation claim, it would be included in the original injuries case. So what's the hindrance to recovery theory? Basically, it's where an unrelated condition is accepted and treated by workers' comp because it's preventing the treatment of your work-related injury. For example, Say your work comp doctor can't give you an injection in your neck because you have uncontrolled hypertension. So in that case, workers' comp would have to pay to get your hypertension under control enough for you to get the injection in your work-related neck injury. Even weight loss surgery could be covered if your surgeon says that you're too overweight to have the surgery. Now, this unrelated condition will only be covered so long as it prevents you from getting treatment for your work-related injury. And the last accident case only relates to first responders. And this is under Florida Statute 11218, also known as the heart-lung bill. Here's a bonus case that exists under Florida workers' compensation law, and it's for something that's called workers' compensation retaliation. This isn't a case that falls under the work comp judge's jurisdiction. Rather, it's more like an employment case for wrongful termination. Now, I'm not going to get into all the details about what qualifies as a work comp retaliation claim in this video, but if you're interested in learning more, make sure to subscribe and hit the notification bell so you know when I release that video. I hope after watching this video you learned a little bit more. So if you ever get hurt or injured on the job, you know if you might have a workers' compensation case. So as you can see, Florida workers' compensation law can be really complex, but what can you do about it? Well, you can hire an attorney that's licensed to practice law in Florida and that handles workers' compensation cases, that represents real clients, goes to court, that knows what they're doing. And if you or someone you know were injured on the job or due to the fault of another, give me a call any time of the day or night. I have a 24/7, 365 receptionist, or you can go to my website and schedule a free consultation, or you know what, you can just text me, 561-935-3822. But that's it for this video. If you got value out of it or if you learned something, please hit that like and subscribe button. It really helps me out. If you have a question, let me know in the comments below and I'll try and answer it. Like and follow me on all my socials. And if you want to learn more about me, my firm, Florida workers' comp, or personal injury law, just go to my website, virtualaccidentattorney.com. But that's it for now. Again, my name's Domenic Celeste, the virtual accident attorney. Thanks for watching, and I'll see you in the next video.